Joining us today to walk us through the legal travails facing the vaping industry is Azim Chowdhury. He is a regulatory and public policy lawyer with a focus on food and drug law, and for the past 8 years, he's been one of the most prominent legal advocates for the vaping industry. Azim, thanks for coming on the show.
Thanks for having me.
So let me ask you that about something that's hot on the presses right now, which is the public health lawsuit, and they're seeking to quash the extension of the pre-market application deadline. So for those of you out there that know the numbers, this was the extension of 2022. So what is this lawsuit that they're pushing, and do they have a chance?
Well, they're arguing that the pre-market review process is a required part of the statute, and that FDA, when it comes to that particular requirement, there's no basis in the law to allow them to extend the deadline for pre-market review, which would require all non-grandfathered products, the grandfathered product being anything on the market as of February 15, 2007, to go through immediate pre-market review.
Who are the groups that have filed this lawsuit?
So the public health organizations, Campaign for Tobacco-Free Kids, the Truth Initiative, the American Pediatric Society Association, American Cancer Society. There's a whole list of them. They were supported by another group in an amicus brief, including like 12 different public health organizations. That their position is that FDA doesn't have the authority, apparently, to change that deadline, to use its enforcement discretion to move the date from 2018 to 2022. And they're hoping to vacate the official guidance document, which was issued about a month later after the announcement, that officially extended that deadline. So
we're talking about going straight at the heart of the only thing that has kept the industry alive and with having any hope.
That's exactly right. And keep in mind, the industry, for the most part, has not challenged the vast majority of the deeming rule. We're not challenging age restrictions. We're not challenging the registration and product listing requirement. We're not challenging ingredient disclosures or health document disclosures. We're challenging the right to make certain claims about products, truthful claims. And we're also challenging that FDA should have created a more appropriate PMTA process that considers where these products fall on the continuum of risk. So this concept that the industry is trying to avoid regulation, that they don't want to be, that they're trying to get away from pre-market review, even though cigarettes and the most harmful products are grandfathered and exempt from that same process, is just not true. And so, here we are, the only thing that has kept the industry alive today, and again, which has allowed more people to continue to transition away from smoking, has been the deadline extension to 2022.
So Azim, things like this, matters like issuing guidance, matters like setting deadlines, are these not exactly the kinds of activities that Congress has in mind when they shop out these responsibilities to regulatory organizations? I mean, this is bread and butter, what agencies are supposed to be doing and what Congress empowers them to do.
That's exactly right. And in fact, the Tobacco Control Act actually has precedents within the statute that permits FDA to extend deadlines. For example, the statute permitted tobacco products that were on the market after the statute went into effect in 2009 to submit what they call provisional substantial equivalence reports by March 2011. So there was a 21-month grace period, so to speak, that allowed traditionally regulated products, cigarettes, cigarette tobacco, roll your own tobacco, and smokeless tobacco, to, as long as they submitted a substantial equivalence report to FDA by March 2011, they were allowed to keep those products on the market. FDA is effectively mirroring that process with these compliance policies in the deeming rule. And to argue that they don't have that authority makes little sense.
So are the proponents of this lawsuit, are they kind of asking for a jury nullification kind of a attitude?
What they're saying is that because companies are not being forced to submit PMTAs right now for their existing products, that this somehow hinders their ability, the public health group's ability to do what they do, which is educate the public on the harms of tobacco use and the effects of different types of tobacco products. And they're saying that they need the information that would become publicly available by companies filing these applications in order to do that. And without that access to that data, because of the delay, they're forced to spend money to figure it out on their own. FDA has already responded to their motion for summary judgment and made clear, in my eyes, to the court that that is simply not a viable argument, that that's not an injury that's cognizable, as the court would say, because that's their job. I mean, they've already been reviewing, it's been their job to figure out how to educate the public on these products, and frankly, have been doing a lot of misinformation over the last several years.
How is it that these groups can be so vicious, so relentless, so willing to completely disregard common sense, yet on the one hand, they actually are starting to begrudgingly accept and publicly acknowledge that there's health benefits to e-cigarettes, but on the other hand, they're still in court trying to kill the industry?
Well, I think that's a good question. I think there's two parts to it. On the one hand, I think there is a deep-seated ideology about tobacco, and all tobacco products must be bad, and that innovation in this industry is never good, right? It can never result in a public health benefits. And I think that's just something that they've had a hard time grasping, that this is not the big tobacco industry. This is not tobacco, and this is a new industry, that you shouldn't apply those old, dogmas to these new actors. But the other part of it is, frankly, not quite understanding what is involved here. And the reality of these are small businesses that don't have the resources to do what is being asked in the time that is being asked to be done. And that these are real people that are helping, that are doing their best to comply with the law and want to live in a regulated environment, in one that helps people. And so I just think there's a lack of common sense, lack of understanding about what the reality is of these requirements.
Can you call out their hypocrisy in court?
That's one of the first things we do in our brief. If you take a look at our amicus brief, the very first page, we highlight FDA's own comments. We highlight the plaintiff's own comments about the benefits of these products. We've done it in the Nicopure right to be smoke-free litigation. We show we're FDA, and we know this, not just in the Deeming Rule itself, but Gottlieb has said on numerous occasions that these products could provide a public health benefit, that they do. And so has Mitch Zeller, the director of CTP. So yeah, we're bringing that to the table and showing the court that these are things that are being said. These are truthful statements. Number one, we should be allowed to make them too, as an industry, and communicate that to adults and consumers so that they understand, because there's so much misunderstanding. There's so much miscommunication about how harmful these products are, about nicotine, etc. And so absolutely, we use the courts as an opportunity to show them that here's what's being said about these products and what the truth is.
Do they have a hope in hell of winning?
From my point of view, and the point of view that we tried to make clear in our amicus brief that we filed on behalf of the Right to Be Smoke-Free Coalition, is that these are not valid arguments, that FDA does have the ability to choose how and when to enforce the statutory requirements, including changing those deadlines for those applications. The issue, however, is making sure that the court and the judge understands that. And if you read the briefs in these cases, you will see that they paint a very one-sided picture of this industry. And the picture that they paint is of an industry that is designed to attract youth to harmful tobacco products and addict the next generation of tobacco users. And what we wanted to make sure that we made sure the judge understood is that that's not the whole story. That's a very small part of the story, that these are life-saving products that the FDA itself and many of the plaintiff organizations have already stated numerous times, including the American Cancer Society, including the FDA. We want to make sure that the judge here in this case in the district court in Maryland, understands that these are not just the next evil invention from big tobacco. That there's another side of the story here. That these are helping millions of people live healthier, safer lives, and we presented those facts to the courts, as well as the fact that it simply would have been impossible to get through the PMTA process during the initial 2-year compliance policy. So at a minimum, the industry needs until 2022, if not longer, to be able to prepare adequate data to support whether or not these products are appropriate for the protection of the public health.